I have a couple of questions. One is sort of a micro level one for Jean, and I may have missed it in your presentation, but I'd be interested in your view of the corporate winners and losers inter se in Quebec. It's usually the case that agriculture is always a winner in these things, but I don't know if that's the case or not. It's more explicit, I think, in the case of British Columbia and Alberta. They clearly make some provisions for different corporate sectors. I guess I wasn't as clear whether that was true in Quebec. And the second question is for both of you, and that is with respect to the federal legislation and most recently the federal pricing announcement that's come out. How do these three jurisdictions view themselves vis-a-vis that legislation? Do they essentially think they're already in conformity, so it's largely irrelevant, or is there more to come there?
OK. Je vais vous parler de la situation du Québec. Le Québec, d'après ce que je vois et des contacts que j'ai avec les fonctionnaires du gouvernement, considère effectivement que le marché du carbone québécois répond aux attentes du filet fédéral, du filet de sécurité fédéral. Et la principale raison, c'est que le carbone est tarifé au Québec. Toutes les émissions de carbone sont tarifées. Les seules choses qui y échappent sont des émissions reliées au carburant d'aviation et aux carburants utilisés dans le transport maritime. Alors donc, tous les carburants, tous les combustibles sont assujettis à un prix carbone, et ce prix carbone va respecter les étapes ou les niveaux qui sont fixés dans la loi fédérale, commençant à 10 $ en 2019 et augmentant de 10 $ en 10 $ à toutes les années. Évidemment, l'augmentation du coût des droits d'émission du Québec va devoir suivre les niveaux fédéraux. À l'heure actuelle, le prix du crédit carbone québécois, attendez, j'ai mentionné, je pense que c'est 19 $ et c'est ça, 19,57 $ ou 19,77 $ la tonne. Alors, ça respecte évidemment le prix de 10 $ fédéral qui s'appliquera l'an prochain, d'autant plus qu'à tous les trimestres, ce prix-là augmente. Et ce qui risque d'arriver, l'effet de la loi fédérale, c'est que, va sans doute être le suivant, c'est qu'en 2020, il va devoir sans doute y avoir une accélération de l'augmentation du prix carbone qui est vendu aux enchères, de sorte à respecter donc les plafonds, les planchers. C'est un plancher fédéral de 10 $ en 2019, 20 $ en 2020, 30 $ en 2021. Alors, le prix du crédit carbone québécois vendu aux enchères va devoir suivre le niveau fédéral. Alors, essentiellement, donc, le point de vue du Québec, le Québec considère que son régime respecte le filet fédéral parce qu'il s'applique à tout et que les niveaux le prix du crédit carbone sera conforme, est actuellement conforme et va continuer à l'être. C'est la volonté du gouvernement. Et le gouvernement va faire en sorte qu'aux enchères, les prix du crédit carbone soient effectivement respectueux du niveau que le gouvernement fédéral va établir, en fait, a déjà établi dans la loi pour les années 2019 à 2023, je pense.
So the response, not surprisingly, is different in BC and Alberta. BC's been pretty quiet. It's pretty clear they comply, and they're going to comply with the Pan-Canadian carbon price through to the $50 a ton price, and as I said, meeting that requirement 1 year in advance. Since the minimum scope of what has to be covered is defined based on British Columbia, they're easily there. For them, in British Columbia, the controversy is more between the Green Party, the coalition members of the current government, and whether there should be any concessions to LNG and other industry, providing some sort of relief from the otherwise escalating carbon price. So their conversation is quite different. In Alberta, it has been the opposition party, the official opposition party position that they oppose carbon pricing, and so this has provided the opportunity for them to just sort of push that political agenda, I would say, and their response, particularly in relation to the federal government announcement, is that the Alberta government is involved with some kind of tax grab because they are giving back or rebating less to Alberta taxpayers than would be the case under the federal federal plan. Lost in that conversation, and I guess it doesn't make for a good soundbite, to give the full explanation, is that Alberta has made the choice, like Quebec, to use some of the revenue to fund transitional measures, and particularly one of those is money from the carbon levy is helping to fund the transition away from coal-fired power, and it's also funding a capped price on electricity that is keeping electricity prices low during this transition period. And so the government has made a policy choice to ensure that low and medium income families receive a rebate that in most cases, from what the economists tell us, will be equal to or more than they're otherwise spending on the carbon levy, but some of that money is being held back to help with that transition. So the conversation point there is why it looks different from the federal government's policy, and it's really interesting that in the neighboring province, the conversation around the rebates coming from the federal government is the opposite. They're not giving, why isn't the Alberta government giving more back to the Albertan people is the conversation from the Albertan opposition, and in Saskatchewan it is, why is money going back? Is it some way to try and buy the public's support for this policy? So there is a lot of there's a lot of politics lying behind some of the conversation, for sure.
Sharon, looking at British Columbia, is there any indication of litigation or proposed litigation to challenge the system in British Columbia? And I'm thinking even over to the Aboriginal rights possibilities. I find it hard to believe that the environmental NGOs in BC are going to take all of this sitting on their chairs.
To challenge the carbon pricing?
Yes.
I have not heard that. I think that there's actually quite broad-based public support for carbon pricing in BC. There is, of course, a lot of energy around the LNG approvals, and whether that translates into a focus on the carbon price or not remains to be seen. Right now, there would have to be some sort of legislative change to make that happen, so the BC Carbon Tax Act would have to be amended, and so that would be I would expect the first place that we would see that legal conversation before we get to the courts.
I was thinking of the LNG approvals and thinking about one of the first slides that you put up that showed the relative contribution from oil and gas, Alberta versus BC, and how that is going to change.
Well, so there is challenges. I don't know if they're based specifically motivated by greenhouse gas or other concerns, but it may well be a part of it. There is an individual who has applied to the NEB to say that this is an interprovincial pipeline issue because the pipeline that's feeding the LNG Canada will connect into Alberta, so there is that issue. The Gixsan have issued a statement saying that they do not consent to the pipeline crossing their land. So there certainly is opposition building in relation to that project, but I don't know if it's specific to the greenhouse gas concerns or broader environmental concerns.
I just have a very brief question. Sharon, you mentioned, I forget whether it was in the Alberta or the BC context, and it may have been both, the term that you used, I believe it was emissions-intensive trade exposure. And I'm curious, it's not a term I'm familiar with. Is there a performance-based or a prescriptive metric that is used to determine from industry to industry or trade group to trade group what constitutes emissions-intensive trade exposure? If you could perhaps define it a little bit for me, I'd appreciate that.
So the emission-intensive trade exposure is defined in one context in the Alberta regulations, and that is for the purposes of the opt-in provisions for industry with emissions between 50 and 100,000 tons of CO2 equivalent per year. They can opt in provided they're trade exposed, and then there is quite a detailed definition to describe when it is that such an industry would be considered trade exposed and therefore eligible to opt in. The fact that they're over that 50,000 ton threshold makes them emission intensive, but the real issue is trade exposure. From Alberta's perspective, it's the converse, though. It's that the presumption is that everyone that's 100,000 tons or more they're emission intensive, but are they trade exposed? There hasn't been a working through of industry by industry to check against a clear definition to say yes, this sector is trade exposed. They need the protection of this special system, and that's where the conversation needs to continue.
La question est pour Maître Piette. Est-ce que vous avez vu dans votre pratique quel est le traitement fiscal des unités, des crédits qui ont été accordés gratuitement aux entreprises? Comment c'est traité par les autorités fiscales?
Je ne peux pas vous donner la réponse. Je sais cependant que la question du traitement fiscal des unités gratuites a fait l'objet de discussions entre les autorités fiscales québécoises et fédérales. Cependant, je ne sais pas quel est le résultat de ces discussions, mais la question, effectivement, a été posée. Est-ce qu'il s'agissait d'un avantage qui était peut-être imposable? Alors, je ne peux pas vous dire là, quel est le résultat des discussions, mais c'est un fait, c'est une question là, qui s'est posée. Il y a une question également, ma collègue ici, Sharon, parlait des entreprises qui sont exposées au commerce international. C'est un fait que, si je veux parler pour les entreprises québécoises sont effectivement en concurrence à tous les jours avec d'autres entreprises dans les autres provinces canadiennes et aux États-Unis. Il est évident que les produits qu'ils produisent, qu'ils mettent en marché, doivent normalement, en tout cas au Québec, inclure un coût carbone. Donc, ça coûte plus cher produire un certain nombre de produits au Québec comparativement aux mêmes produits qui seraient fabriqués en Alabama ou fabriqués dans d'autres provinces canadiennes. L'avantage de la loi fédérale, c'est que la loi fédérale va établir des règles du jeu uniformes dans toutes les provinces du Canada. Même si les mécanismes de conformité vont varier d'une province à l'autre, il y a quand même les entreprises vont être assujetties à un prix carbone au Canada. Mais la difficulté pour l'instant, c'est quand elles sont en concurrence avec des entreprises américaines où il n'y a pas de coût carbone, sauf en Californie. Là, les entreprises québécoises sont dans une situation défavorisée. Et les allocations gratuites sont justement conçues pour essayer d'atténuer l'impact du coût carbone payé par les entreprises. Alors, je vous mentionne ça là comme étant un des éléments, une des caractéristiques du marché du carbone du Québec.